Um, I'll introduce myself here. I'm, as you probably know, Henry Kass from Marabella Kincaid, Frederick and Marabella. I am the chair, at least for one more month, of the family law section. I'm going to be one of the moderators today. One of the other moderators is my vice chair, Vicki Kelly from Grunick Family Law, who will be taking over as chair of the family law section next year, and who will be monitoring your question and answers, or your questions rather, as they come through, is our president-elect, Wendy Muselik from Andy Corey's Family Law Group. Before I get into introducing the judges, because remember yesterday was our first day where the judges were back at the courthouse and they are attending court calls right now. So we're still having some of them join us, and that's just fine because that's going to give me a little bit of time to do some announcements. We have a lot of things that are still going on and things that have been rescheduled, and some opportunities for MCLE credit that I want to advise everybody because I know we have a deadline coming up, although I believe that deadline has been pushed out for those of you who need it. So first, the Lawyers Lending a Hand and DuPage County Courthouse Joint Drive-Through Food Drive is planned for next week, not next Wednesday, not tomorrow, but the following, May 27th, in the parking lot of the DuPage Bar Center, and that's at 126 South County Farm Road in Wheaton. All donations will go to replenish the inventory at the Milton Township Food Pantry. Items needed include non-perishable, shelf-stable food, general hygiene products, and basic household items like paper towels, laundry soap, garbage bags, etc. Please consider volunteering on May 27th, again that's a Wednesday, to assist with collection if you can, and plan to make your donations now. Early donations can be made at the Milton Township Food Pantry. Also, with regard to the DuPage Bar Foundation, all DCBA members in good standing are encouraged to consider placing their name into the nomination for the DuPage Bar Foundation Board. To be considered for appointment, simply complete and submit an application available on the website by May 31st. Applications will be considered by the Bar Foundation Board through early June, and new members will be installed June 22nd. Up to 6 seats are available, and the need is great for a wide array of experience. Contact DuPage Bar Foundation President-elect Mia McPherson for more information. Some upcoming MCLE events. A week from today, Tuesday, May 26th, the Children's Advocacy Section will be hosting their remote MCLE program. It's entitled Guardian Ad Litems and Gathering Information from Third Parties. The speakers will be our own Honorable Judge Linda E. Davenport and Emily Rapp from Magnuson Rapp Law, LLC. Again, that's next Tuesday, May 26th at noon. As far as our section, the family law section, will also be hosting a remote section meeting in June. It'll be our last one, June 16th, 2020. The title is DCFS Investigations and Appeals, and our presenter will be Missy J. Cuffle. Again, that's DCFS Investigations and Appeals. That's June 16th. A few more announcements on some events that have been delayed or moved around. We are going to have a small event to recognize the installation of our own Wendy Muselik as DCBA president, the 2020 to 2021 officers, and our new directors. And this small event to recognize the installation is scheduled tentatively for June 19th of 2020. Again, that's June 19th. I believe that's a Friday. Now, the formal DCBA installation will take place on Friday, September 18th, much later in the year, where we hope everything will be okay. Also, the DuPage Association of Women Lawyers installation, which was originally scheduled for May 28th, has been postponed and will now take place September 24th. That's September 24th at Arrowhead Golf Club. The 2020 DCBA golf outing will be Wednesday, August 26th. Again, that's Wednesday, August 26th at Naperville Country Club. It'll be nice for all of us to get out and enjoy some weather and socialize again. And the DCBA and DuPage Association of Women Lawyers will be hosting a joint judicial reception on October 22nd at the Donata House. Again, that's the DCBA and DuPage Association of Women Lawyers hosting a joint judicial reception on October 22nd at the Donata House. Okay, so I'm going to peek back in here and see what judges we've had join us, and hopefully I'm not going to miss anybody. And I may announce some names of judges that are still conducting their court calls and will be joining us shortly. So we have our presiding judge of the Domestic Relations Division, Timothy J. McJoint, our circuit judge, Richard D. Felice, Circuit Judge Linda E. Davenport, Judge Neil W. Cerny, Judge Elizabeth W. Sexton, Judge Ann Thoreau Hayes, Judge Michael W. Reidy, and Judge Susan L. Alvarado. Thank you all very much for being here. And again, some of them may not be with us yet, but we're anticipating that they will be joining us very soon. Before we get started now, Judge Joint has some comments that he would like to make and perhaps some new developments that are coming about for the third floor in the courthouse.
Thanks, Henry. A few things, hopefully shorter than the last time. Some of the domestic relations courtrooms have court call phones on their bench, and they are functional, but we're not using them yet because we're not ready. We haven't been trained, and some of the other courtrooms haven't gotten theirs yet. For whatever reason, court call has allowed, I guess, the scheduling of a court call event without consulting with us. So if you got a court call scheduling, it's not going to go ahead. The judges are going to disregard it because we're not ready for it yet. The procedure that should occur with court call is that they have to get a date from us, or you have to get a date from us meaning our schedulers, our secretaries, for either prove up presentment, status, or hearing before you can go then to court call and schedule it. We're basically setting up that firewall with court call right now. So if any of you have done that, it's not going to work out for you. Court call probably will be up and running for all of us in another week or so. But again, the procedure is you got to get a date from our schedulers first and then set it up with court call. And that's the next topic. We are giving out all the dates, as I think you probably know from the last time, for all events. Meaning pretrial, prove-ups, presentments, statuses, and hearings and trials. There are time slots all spread out through the whole day for all of these events, and we are scheduling them, and we are running our own, basically, limits on how many people and how many cases we can have each day. So you cannot get a date from the clerk's office. If they give you one, they're doing that in error. You can only get dates for all of our courtrooms, for all of our events from our schedulers. So in summary now, what's going on is all judges are on the bench hearing their call. Everybody's back. The doors are open. The only thing that you can do in person in the courtrooms is returns on orders of protection and emergencies for that judge. One of the questions I just read over was, does a duty judge hear something? There are more duty judges. They're gone. Everybody's back. Everybody's hearing their own call. So, for example, today I had maybe 20, some statuses, some presentments, and a couple of hearings. Of course, the hearings didn't go. About 5 or 6 of the cases called in, made a Zoom reservation, and we Zoomed and handled the case. And then talked about new dates. And then the judge, me, entered the order. Okay? For those cases that were on my call today that no one did make an advance or reservation for Zoom, I gave the case a new date. What I did was I struck all the clerk dates that they gave out and gave you a date out. And it's generally for status. So you now, lawyers, have the obligation to go find what date I gave you and what dates I struck. I'll get into how far out I'm pushing the cases in just a minute. So that's what's going on right now. If you want to get to us, you got to make a reservation on Zoom, or you got to set up a court call event, which again isn't quite ready yet, or you can set up a telephone call, plain old telephone call, speakerphone on the bench. But all of those events have to be scheduled through our schedulers. We enter a court order, then you're on ducks, then you're on the call, and we will then be able to address your case's needs with one of those methodologies. Pre-trials are a little different. They're off the record. It's up to the judge, individual judge, how he or she wants to do that. You can do it over the phone. You can do it from home. I don't care. That's a little more informal, to say the least. So that's what's going on. The volume of Zoom reservations is incredible. and it has grown dramatically since our last meeting, basically. We have 4.5 people handling this. I had a meeting with my judges on Monday morning. I said, it's like a 100-table restaurant, and we only got 4 waitresses. We're getting killed. They're getting swamped. They're working way long, early morning, late at night, to schedule all these events for you, because everyone has now discovered this is the way. And all I can ask is, please be kind to those folks, because they are really working hard. And be patient. They may put you on hold for a while. They may tell you there's no more slots available for that day. Be nice, because they're really, really, really doing the job. The last, I think, important thing to talk about, and the last important thing I think we need to talk about is there's a new administrative order coming out. I don't know when. I'm pretty sure I know what it's going to say, so I'm going to tell you what I think is going to happen. I'm pretty sure. But as we know, or maybe you don't know, things have been changing daily. In any event, the courthouse is going to open to people coming in the building in this way. Criminal and traffic, end of June. That's right, the end of May, or basically June 8th, okay? Domestic relations, end of June, not 6/8, 6/29. Civil will open up end of July. So we're opening up by floor, basically, to ease into the traffic that we're going to have when this place is wide open again. And I should add an additional traffic court is coming this way. So there's even more people that are going to be in the building. In any event, so that last bit of information, obviously now you're thinking, holy cow, we're not going to be back in the courtrooms on June 8th, as I told you last time. That is a correct statement. I moved the goalpost on you. Ha! In any event, your problem is if you set cases for in-person activity, and if you note, all the orders now at the top generally say Zoom or in person. So we kind of know what we're planning on. If you've set in-person orders for June 8th, after June 8th until June 29th, you have to fix it. It won't happen. You got to come back and make a reservation for a Zoom for that date or change the date. Can I tell you 100% that June 28th is the final, real date we're all going to be seeing each other again? I cannot. I can tell you, though, that it's a really good bet. And unless something terrible happens with the state of the health of people in the state of Illinois, or Governor Pritzker does something else, that's probably when we'll all see each other again.
Right.
So that's it.
Your Honor, you said that date for the domestic relations, because we've already seen some people chiming in and asking. That would be June 29th. That's a Monday?
It's a Monday. I said, I'm sorry, I misspoke. 6/29.
Okay. All right. And before Vicky's going to start off with our first question, and some of the questions that we're going to be asking first are questions that people submitted through email to me and to Vicky and Wendy well in advance of this program. But we're not going to be able to have the program run as long as we did last time because all of our judges are back and they have court calls to attend to. So we'll most likely be ending promptly at about 1 o'clock. But Vicky, if you want to go ahead with the first question then.
Sure. The first question is for Judge Davenport. This attorney submitted a few different judgments, a consent judgment, prove-up documents, with a judgment for dissolution of marriage. They submitted documents to 2 different judges this past week, but they haven't received anything back, and the judgments are not showing as entered online. How do we know if our judgments were accepted? Is their client divorced? How do we follow up, or who do we contact if we haven't heard? And what is an appropriate time to wait before following up? Oh, Judge Davenport, we can't hear you.
Better?
Yes.
Thank you. Sorry. Couple things. Number one, when we enter the order here, you have to assume it's going to get scanned, so it won't show in Ducks probably at least for 24 hours, if not 48. So I would start by saying 48 hours after you know that the order has been signed. So the first question is, how do you know that it's been signed? So let's start with the easy ones, which are prove-ups. So if you have a prove up that you're doing by affidavit and you send in the judgment, assume for sake of argument that if you sent it to the correct email, which that's sometimes being a problem, make sure you always use our official emails. And this is just a quick note about the Zoom invites are coming from our personal emails. You're going to hear a lot about this morning from every one of us, but please don't respond to the personal email. Always respond your acceptance to not just the person who issued it, the judge's personal email, but the actual like linda.davenport@18th Judicial. That's the official one that we need to be going through. Especially if you're copying clients on things, please don't give them our personal emails. So to answer your question directly about how do you know that it's been entered, you're going to have to go on to CRIS, the system from the clerk's office, to see if that order was entered or that judgment was entered. I would say 2 days, 3 days at the most ought to be there. So what I'm doing is on orders, when I have Zoom hearings and I say I'm writing an order, which by the way, you know, the judges are writing all of the orders. The judges are doing their own invitations to Zoom. So expect that when we have to do 20 and 25 a day for future dates, some of us type faster than others, so give us a little bit of a break. So when we send these out, we're sending them out, and then you have to also call in and schedule the date. So our orders will say we have a Zoom conference set for July 14th at 10:40 for status. That doesn't mean that you have an automatic Zoom appointment that day. You still have to call the schedule, as Judge McJoint said. But to check up on things, really give it 72 hours. If you don't see it in there, call the judge's specific secretary or assistant and ask them, or send them email that says, this date, this was sent in on this date. We don't have confirmation that it was entered, so that the judge can then get that information and follow up on it.
Thank you.
Right. So, and I want to also mention that we've had the Honorable Judge Robert E. Douglas join us. He's sitting there with Judge McJoint. I did not introduce him previously. The first question that I have is for Judge McJoint or Judge Douglas, whichever of you might want to answer it. This is probably number 1 on your list here. It says, if you currently have a previously scheduled date on or after May 18th, and you have not called the judge's clerk to schedule an appointment, will your case automatically receive a new date? I think we already know the answer to that, and that answer is yes. But the second part of the question, and I think Judge Davenport just answered it, is will the lawyers then still have to contact the judge's clerk to request an appointment? So I understood it. The answer to that is yes. Is that correct?
Yeah.
Okay. And the rest of the answer then really, or the rest of the question really then becomes moot. So, Vicki, I kind of went out of order here. Do you want me to go ahead with question number 3?
Yeah, go ahead.
Okay, so this is going to be a somewhat detailed question. It's a little specific, but we're gonna. It was one of the first questions that was sent to us with respect to orders of protection being heard by domestic relations judges. It says, for cases between May 19th and June 5th, will these cases be heard by the duty judge? Well, I think we just heard Judge McJoint say, no more duty judge. All the judges are back. They're all back as of yesterday, May 18th, so they are being heard by their assigned judges. The next part of the question is, do attorneys need to take any action to confirm these hearing dates? I think the answer is yes, but Judge McJoint or Judge Douglas, I'll let you answer that part.
The orders of protection, usually they start in 4016, and when there's a D case, then the order of protection is consolidated into the D case, and given it a date at 1:30. Each judge has a day for orders of protection. Each domestic relations judge has a day. Count on being there that day. Those are not continued. Those will not be continued. They'll be heard. Statutorily, they have to be heard.
Okay. The next part of the question is similarly for cases to be heard June 8th and after, and I guess that's going to change now to June 29th and after. Do we need to take any action to confirm the already set hearing date with the assigned domestic relations judges? Again, I'm going to assume that the answer is yes, you need to take action to confirm the date, but what about after June 29th then? What will the procedure be?
Any dates that are set after June 29th are going ahead for whatever they were set for. And I should warn you one of the earlier administrative orders said, we're going to, Chris Gratz was going to kick all the cases out for status. On the last go around, we didn't have our cases on the third floor kicked to status. We had them kicked to the same time frame for the same purposes as they were set for. So if it's at 9:15, it's an old presentment. Obviously, we don't do them at 9:15 anymore. But it could be a hearing at 9:45, which again, we don't do those anymore. But at this point, it's going ahead.
Right. The next part of the question is, again, I think something we've already touched on a little bit, but for clarification, and because some people may view orders of protection as trials if they last an extended period of time, or hearings if they're only going to be, our typical 20 minutes. Are these going to occur in person, or are they still going to be through Zoom?
You talking about orders of protection?
Yes, on orders of protection specifically.
They're not Zoom. They're in person.
Okay.
By the first administrative order. And that's never changed. So the judge is going to hear that in his or her courtroom, live, in person, with the participants.
And that's even if it's not being brought on an emergency basis. That's even if the emergency's already been issued and it's now for return on the emergency. In other words, for hearing on the interim or the plenary.
Yes. And,
okay.
One more thing I want to add, because Judge Davenport just sent me a message. Understand Zoom doesn't end on 6/29. You can still do it.
Okay. And then the same individual has a follow-up, and that is, what is the status of family shelter returning to the courtrooms to assist with these orders?
Okay. That's, of course, that's Chief Judge Guerin's call. The administrative order that's about to come out maybe this week may address those topics, may not. That topic includes library, cafeteria, marriages, juries, probation meetings, lots of things. It's not just the shelter. And they're all going to probably open at the same time. When? I'm not sure.
Okay. This is the last part of the question. Since these hearings are going to be done in person, for orders of protection, again, I'm specifically talking about orders of protection. Since they're going to be done in person, the person asking the question is wondering if they know that the case is going to be continued. Like oftentimes we might have an issue where the respondent hasn't been served, or something along those lines. Is it still necessary to have the client show up if you know it's just going to be continued for service or for something else?
That's not a COVID question, is it? Right? I mean, that's your call as a lawyer representing a litigant. It has nothing to do with whether we're open or closed.
Right.
So use your best judgment, I guess. Be a lawyer.
That might be the answer for some of the questions that we have coming down the pike.
Okay.
The next one is for Judge Sexton, and it's not a COVID-related question, but it is a judge's panel, so we figured we'd throw it in. Has a decision been made for all the judges to use a specific website or specific software for the calculation of maintenance or child support, or does it remain up to each judge individually to decide?
It's up to each judge. Everybody does it a little differently. My pro se's, we pretty much go by HFS simply because it's easier and they have to do it. But I think other judges like the specific. I think it's very discretionary at this point.
Great, thanks.
And I know that that's been kind of a growing issue among some different attorneys, with obviously that there is some discrepancy in the calculations that HFS provides on their website calculator and the ones done by Family Law Software. Moving on though, Judge Felice, who has joined us, the next question is for you if you're ready.
Yeah.
If a parent, this is kind of the opposite of what we're accustomed to being asked. If a parent has not taken their parenting time as a result of COVID-19, and the parent who has the children the entire time really wants the other parent to take the kids, what is the relief that can be asked for? Can the court force the other parent to exercise parenting time?
Well, I think that's a problem that we've seen before COVID-19, when a parent that has time with a child or children doesn't want it, doesn't take it. And that's always problematic, to force a parent to take the time. Unless there's something specific in the agreement that would create, I think, some argument, it's a difficult argument to make that you're forcing somebody to take time they don't want. Now, obviously, they can bring other issues into the fold, and possibly other motions might be filed if a parent could care less in having their children. But I also think it would depend on what their reasons were if that came down to it. Was there a COVID-19 problem that they were facing? An example, if they were a first responder, they may have a reason as to why they don't want to have the children. So there's a lot more facts that have to be noted, but I think to force the other parent to take the children as a general proposition is always difficult. And it's going to have to be very fact specific as to why you could force that issue.
All right, thank you.
Judge McJoint, this one's for you. Some other counties are currently keeping status dates as originally assigned and are having all the attorneys log into Zoom while the court conducts their status calls. Thereafter, the judges are calling one case at a time. Is this something that has been considered in DuPage County? Would this move cases along faster for statuses and presentments, or at least allow more cases to be heard in one day?
We're aware of that methodology. We elected not to use it. The main reason being it's an open forum or open format. It can be Zoomer bombed, it's called. It can be invaded, and it can be a lot of problems with it because literally anybody can just hop on. We elected to go with private, individual invitations to avoid that consequence. Would that methodology maybe speed things up a bit? I don't know. You know, whether you're coming here at 9:15 or 10:45, if you're on time, what difference does it make to the lawyers? It's the judges waiting around for you, but so I'm not sure it would improve your conditions, the lawyer's conditions, that much anyway.
Thank you.
Great. The next question is for Judge Cerny. The question is, will there be a relaxation of the rules regarding courtesy copies submitted by email? I know that a lot of people have been asking this. Right now, the rules limit email attachments to 25 pages and allow only one email per presentment day per case.
Thanks, Henry. I'd be surprised if anybody would want to relax that rule because we don't want to be inundated with a lot of documents. So I guess I would just go back to the way we've always done it. If you want to send more than the limit, you have to get approval from the judge beforehand in order to receive excessive amounts of paper. So I guess my point is that the rule still stands.
Okay.
Okay, Judge Alvarado, this one's for you. This attorney indicated that on Thursday they will have their first Zoom prove up. She submitted the documents ahead of time. Specifically, there's an allocation judgment marked as Petitioner's Exhibit 1, a marital settlement agreement marked as Petitioner's Exhibit 2, and a detailed financial spreadsheet, which is marked as Petitioner's Exhibit number 3. How will the exhibits be displayed on the screen for her client to identify? Does the judge, the clerk, or does this attorney need to put it on the screen? She indicated that usually in person, she requests that the detailed financial spreadsheet be withdrawn from the record and the judge hands it back to her. So how will that work?
Okay, well, first of all, the attorney here did it right. That is, he or she did submit all the documents ahead of time. So that's actually important that you do submit these documents to us certainly more than one day in advance. You know, I would say 4 or 5 days in advance would help us a lot because those documents go to our secretaries. And as Judge McJoint has pointed out, they're absolutely overwhelmed. So they need some time to process them and get those documents to us. Once we are online and we're doing a Zoom prove up, while I've not yet done one, and we just had some Zoom training yesterday, I believe that what would have to happen here is that the judge or the person hosting the meeting, who will always be the judge, will share the screen, I think, and we will be responsible for sort of posting the document for the parties to identify their signatures thereon. Now, I could be wrong about this. I'm not 100% sure because we haven't done it yet, but that's my best guess on that. As to what to do when you wish to have an exhibit withdrawn, you know, I'm guessing here, again, we haven't done it yet. I'm guessing that we would just hold that aside and then you would send somebody to pick it up in person.
Thank you. And then following up to that, Judge Hayes, how far in advance should we or our clients expect to receive Zoom invites for prove-ups? What can we tell them? Oh, you're muted, Judge Hayes.
There we go. Thank you.
There we go.
I can only speak for myself. I'm trying to do them as I get them in. So, you know, even if they're far out, just because we sort of have a lot of paperwork with this new system, which is fine. So, you know, as soon as you schedule them, I'm trying to set them up. Other judges are kind of doing maybe a week out. And I know that some of our judges have had some issues with email transmission with the Zoom, but I think those have been straightened out. But just on that, just to clarify, we get a piece of paper that you folks fill out that basically says the reason you have it on the call, the time and date, and who you want us to send the invite to. So I am only using the emails that are on that piece of paper to send the invitation to. And I've already gotten feedback, well, you didn't email this person. Again, so it's really important if there's a GAL, we don't know, maybe you don't want the GAL included, or you know, it's really important, everyone that you want to be included on that Zoom call, make sure you put on that piece of paper, because that is what the judge is using to send the Zoom invitation to. So if there's not an email address on there, I'm not sending it. So hopefully that answers that question. Thanks, Vicki.
Yes, thanks.
One more
Vicki?
follow-up.
Judge McJoint and then Judge Davenport.
Yeah, Judge Felice has a comment about multiple emails to the same law firm. Judge Felice?
Correct. I just filled out a number of the invitations based on the reservation request. And in one instance, there were 3 different email addresses for the same law firm. Apparently one to send notice internally to the law firm, and then there was to a senior partner and then a junior partner or associate in the firm. That really is unfortunate, because we're already loaded up with doing a lot of these invitations. And if it could be streamlined so that at least you get one invitation for the given firm. The other issue that's come up is now some of the lawyers are listing email addresses for their client at Hotmail or what have you. And one of the questions that I actually raised with Judge McJoint this morning is, you know, it's difficult for us to communicate. It's probably not a good idea directly to the client, and that's what we're doing when we do it that way. So the other option is that the lawyer can forward the invitation onto the client. So we're not directly communicating with these people that are represented. But that's also been noted. On one of them, there were 5 people, no, actually 6 people. Three different emails for one law firm, another email for the other law firm, and then 2 litigants. So I just point that out. And the other point that's very important is that make sure your email addresses are checked and double checked, because in a couple of these instances, they were rejected, even though they were exactly reproduced as on the reservation. So make sure you check that. Otherwise, that person's not going to have the invitation, or we get a rejection, and now we got to figure out why has it been rejected. Okay.
And Judge Davenport, you wanted to add something?
I did a prove up this morning. There were 2 attorneys. One party was in the car using their phone, and then the other party was not present. As to the document not being admitted into evidence, what I told the attorney was, I reviewed it. It had been marked as an exhibit. I got both attorneys to stipulate to signatures, which helped identify all the documents. Then I told them, as to the exhibit that was sent in but was not made part of the record, I deleted it from the email. It's gone. So just make sure if you don't want it included, tell the judge to delete that. That should take care of it. And again, following up on what Rick said, don't put clients on this invite at all, just the primary attorney on each side and the GAL, because again, this is our private email coming to you.
Okay, and Judge Alvarado?
Along those lines, I also wanted to say, number one, as Judge Davenport just said, you know, we're not comfortable sending emails to your clients or invites to your clients, so that's left to you. Unless, of course, it's a pro se litigant, then we have no choice. But here's what's been happening. All of the judges have been doing their best to include sort of a caveat in the invitation, which says, please do not reply to this email address, as you will not receive a response. But I don't think it's being read, because we're getting a lot of responses. For example, here's what happened earlier this week. I sent out a Zoom invitation, got a response, which I shouldn't have received a response, from one of the attorneys that was advising me that she was attaching an agreed order, and that, you know, she was just setting this for status on another date. Well, I'm not even going to open that, so I don't have the agreed order. I'm not accepting the status date, you know, but this is going to be a learning process. Just please remember, if you're communicating with us, always communicate with us via our formal email address, which is always the judge's name at 18thjudicial.org.
Great, thank you.
Vicki?
Yes,
It's Judge Sexton.
yes.
Neither of my computers in my office or on the bench are equipped at this time to send out invitations. We are working on it, but we just found out this morning that there was a technical issue. So I don't know that I'll do any Zooms this week. Just want people to know.
Okay, that's helpful. Thanks, Judge Sexton.
Okay, so before we move on to the next question, the important thing to take away from what Judge Davenport, Judge Alvarado, Judge McJoint, Judge Felice just said is that when you're getting the invites, do not respond to those invites. When you're getting the invites, don't respond to the invites. And likewise, if we're going to be having our clients, and I want someone to correct me if I'm stating this wrong, if we want to invite our clients or want to have our clients present for the Zoom meeting or the remote meeting, we are to be forwarding those invitations on to them so that they are not coming from the judges directly. Do I have that correct?
Correct.
Okay, great. Thank you, you guys.
And would you prefer that we redact your emails? Because I believe they show on there. So when you're
If
forwarding it,
possible.
make sure you redact the details of the email address that it came from.
Yes.
Okay. Right. Next question. This was originally slated for Your Honor, Judge McJoint, but Judge Reidy, I accidentally gave Judge McJoint one of your questions earlier, so now I'm going to switch it around. It's a fairly straightforward question. I'm not sure exactly how to answer it. How should we handle presentations or matters before the court for the first time? I'm, again, assuming that the answer is, you know, the same as we normally would, but I did have a number of people at my office that had presentations for the first time. This morning, they said they went rather quickly, but is there anything in particular that you want us to do or have ready for you on that first court date? You're muted, Your Honor.
Do it the same way.
Okay.
Do it the same way.
Same way. Is there anything in particular, again, since we're so backlogged on things, you know, normally we have a presentation date and we come in, we say, yeah, you know, the parenting class has been done by one party, maybe not the next. We'll give so many days to get the financial affidavit done. Is there anything in addition to what we'd ordinarily do to make best use?
I think Rob may have a comment.
Henry, I was going to say the one thing on initial matters, the clerk is still going to be giving an initial status date when you file your complaint, and that's going to be set at 9/25. Those 9/25 status dates don't exist anymore. So as soon as you file your complaint and you get that 9/25 status date, you need to call our schedulers and set it up as a status on the new status times. And then when you come in, be prepared the same way you would before to say, you know, you're going to, if there's kids, we're going to tell you to have a parental allocation judgment due by the next time, carrying and coping, financial affidavits, all the rest.
Okay, so that's a good comment that you made. So we're still going to be keeping that date, but obviously it's not going to be at the 9:25 time. So even though it may be the same date, it may be at 9, 9:05, 9:15, etc.
Correct, and that's up to you to schedule with our schedulers. We're not going to change it for you.
Excellent. Thank
But I
you.
guess the next question would be, if you're scheduled for a specific date that the scheduler gave you and all of those time slots are filled up, do you just pick a new date? And then what if your date comes and goes? You know, what do you guys see? Because I look at that as I'm missing a court date. Judge Hayes, I see you shaking your head. Do you add in?
That came up today. So when I have cases that no one set up a Zoom call, no one set up a phone conference, I pull it up in the court system and I can see if you've scheduled, for the example that you just gave, oh, I see that she has scheduled a future date at one of the, you know, official new times, then I'm not going to do anything to confuse that issue. So I'm checking. So we're going through our court call on the record, calling each case and saying it's up for status today. This was the status date. And just, if I see a new date that was given by my secretary or any one of us, I'm not going to do anything with that. And just a suggestion on presentments, if you have, you know, a simple post-decree motion, we're still accepting agreed orders. So if you have spoken to opposing counsel, you've agreed to the presentment, you're acknowledging receipt, you're setting out a briefing schedule, and you've selected a future status date with our secretaries, nothing prevents you from entering that agreed order for that presentment, if that makes sense. Nothing, because I had a lot of those today. Well, we're agreeing on a briefing schedule. You can certainly do that by way of an agreed order, as long as you're clearing that status date on the pleadings with our staff.
And I'd piggyback on that is if there's if you have, like Judge Hayes says, if there's agreements between you, there's really no point in us doing a Zoom hearing if you're just going to say we have an agreed scheduling. That's kind of a waste of all of our time. Just get us the agreed order, we'll sign off on it. I would probably, only the other thing I'd add is, like, we've gone through our call. I think all the judges are going through their call. And if you, and I think this was one of the earlier questions, we're just going to choose a future date. But I will tell you then after that, at least I'm likely to either DWP it, or if it's post-decree, just take it off call. So I'm going to give you kind of that one opportunity to, hey, look, and I know this is kind of, you know, unknown to us all, but now once July comes, because I'm kicking my dates, the future dates, the in-person time in July. If you're not here in July, it's either going to get DWP'd or off call.
Great, thank you. Judge Alvarado, we have been told that statuses will not take place on a Thursday or Friday. What if we have a previously scheduled status for a Thursday or Friday? What do we do? And then I got a message to my phone. The reverse of that is, I have a hearing set for 6:30 at 1:30 the day the courthouse opens. Is that going to be continued to a Thursday or Friday since it was set for a Tuesday? What do we do in those situations?
Okay, well, that's a good question. So if it's a hearing, if it's a 1:30, I'm guessing it was a trial. You know, that trials are now happening on Thursdays and Fridays. So the June 30th, if that's a Tuesday, that's going to be changed. Okay. The other question, yeah, statuses are now scheduled for Monday through Wednesday as are presentments. So if you have a previously scheduled status date for Thursday or Friday, it's going to get kicked. So if you don't call and request a new date with our assistant, then on the date you were scheduled, that Thursday or Friday, it's going to be changed. And again, as Judge Reidy said, what we'll do is kick it out till probably sometime in late July for a status. And that will be an in-person because the only person who could request a Zoom is you.
Got it. Thank you. Henry.
Let's see. The next question is for Judge Davenport. The question is, if we have a case that needs to be set for a status, pretrial conference, or hearing, do we need to submit a separate request for each one, or can we put all of the requests on the same form? So if there's going to be multiple court appearances, does there need to be one for each one, or can they just put it all on one form?
I would suggest that it just be all on one form to make it easier for you. I would suggest that we do status and pretrials at the same time so that I can find out what the status is. And at the conclusion of the pretrial, we'll all pick a new date together once I'm on Ducks and can see what dates are available, have your calendars ready, and then we'll all pick the date. As to a presentment, same thing. If you can do it all at the same time, give yourselves a break. If you need more hourly billing, then figure out to do 3 different ones. I'd rather not have that happen. But if I could follow up on one note, Judge Reidy had said, and Judge Hayes too, obviously we will always take agreed orders that are dispositive of all issues. If they're signed off by everybody, clients, everything. For me, a PDF form, you can always send those in if it's dispositive of all issues. However, between now and June 29th, and it isn't set in stone whether it's June 29th or July 6th from what I understood, but more likely than not, they're going with June 29th. So if you have something between now and then that you want to have done and you have an agreed order with the other side and you pick a date of June whatever, and you contact the scheduler and they give you that date, that doesn't mean that a Zoom is set up. So that we're just really clear. You can have an agreed order and you can send it in, but you have to follow up to set up a Zoom if you want to have something heard that day. A presentment, a status, a pretrial, anything. You can do agreed orders all you want that it'll put it on the call, but that won't result in a judge sending you an invitation for a Zoom conference.
Okay. Thank you. All right, so the last question for the sent-in questions is going to be for Judge Cerny. In cases where we have a pro se on the other side or an unwilling opposing attorney, is there any way to force a Zoom hearing?
All right, thank you. Yeah, and I'm not sure which administrative order it was because there's been so many. And it may have been the first one. They talked about that these Zoom hearings, we're going to conduct them as though they were regular hearings with proper notice. And with regards to that, there was a question on the chat about copying the email invitation to the opposing counsel. And I guess my view is that I don't think we should do that. I think that the judge has to email to each attorney so that there's a record that the notice was sent. And then I think from there we treat it as though proper notice was provided. And if someone does not want to participate, I mean, that's kind of like saying they show up to the courthouse and don't want to come into the courtroom. I think we still have to proceed as long as everybody has proper notice that we're going to be conducting the hearing. Now, if there's something, reason why they couldn't do the Zoom hearing, that's going to be a motion to vacate or whatever. But I think there's a general census from the order that we conduct these hearings, these Zoom hearings, as though we were actually in court conducting the hearing. So as much as we can strive to do that, we're going to attempt to do that. Obviously, there's going to be some issues on some matters as to how do we proceed. Prime example would be we issue a rule to show cause, and the rule to show cause that has to be personally served on the person is, is it going to have to now contain the Zoom hearing invitation information. So we haven't come to that yet, but I think the idea is that we want to conduct these hearings as though we were in the courthouse to the best that we can.
Judge Felicia, you have a comment?
I want to follow up with 2 points. There was an earlier question here I was going to answer, but I also wanted to comment further on what has been discussed about the Zoom hearing. First, the question came up, and I think it's already been answered for the most part by Judge McJoint. If you already had an in-person date in June, what's going to happen? Well, you're not going to have an in-person date in June unless it's an emergency matter, and you're going to have to then have a Zoom hearing if you wish to have it. But it doesn't automatically convert to a Zoom hearing. You have to take the initiative and get a reservation, because even though you had a date for your in-person hearing, it's possible that that date has now been filled with other reservations that took the times that were available, and you can't just assume now you'll have those times. Further, you don't have an invitation, so there'd be no way for you to have a Zoom appearance and hearing or presentation, whatever it might be, assuming it was a hearing. Second, and this happened today, I'm not going to mention any names, but you have to be really careful on your Zoom calls. You have to be appropriate. You have to dress in an appropriate way. You really have to have your, you have to have your pants on. You can't be wearing hats. There's a lot of strange things that go on sometimes with these Zoom appearances, so just be careful. Remember, it's being recorded.
That is noted. Judge Douglas, we are getting a lot of the same question on the question and answer. This attorney called to get a new date and was told new dates are only given by a written submission to the schedulers. Would one of the judges please confirm the exact procedure for getting a new date? Written submission, then phone call, or do we submit the written request and wait?
I'm here with Judge McJoynt, and he's the guy who sets the procedure, so I'm going to kind of defer to him on that one.
If you're scheduling a Zoom event, you have to, first of all, get the date and the time slot from one of our schedulers. Then, once you get that date, you need to fill out the registration form and get it to that scheduler. The secretary will then create an order for that date and time, and the judge will sign it. Next, the judge will then make the invitation on Zoom for that date and time. Hope that helps.
There's a number of questions that have been coming in through the question and answer format on Zoom. And I think this was one that might have been touched on last time. I don't know if we got an answer at the time because we were still, developing things, but what is the current process for the substitution of judge? If obviously there would be a presentation of the substitution, I'm assuming that it would be granted if it's as of right. But then as far as it getting reassigned and getting the next court date, what's the procedure there?
Well, that's probably me again. Certainly the procedure is the same. It's how you do it in the land of closed courtrooms and Zoom. You got to go in on a presentment on your SOJ motion. At 9:15, strike that. Whoops. I made a mistake. Sorry.
You know what you meant.
You know what I meant. And at that Zoom event, it will be obviously before the judge that's being SOJ. He then signs the order that then comes to me. Problem is, you can't walk down the hall to me because you're not here. The few that I've had, the 2 or 3 that I've had, I've reassigned the case and I've done an order for a future date in front of the courtroom I signed it to, and I sent the order to the attorneys. A little unwieldy. It's only, like I say, it's probably happened 4 times in the last 9 weeks. But that's what I've been doing so as to not have you come back, or strike that, so as to not have you do another Zoom event in front of me and then another Zoom event in front of the judge that you end up with. Now, the problem with that scenario is you guys, the lawyers, don't have input on the date I picked. That's true. I got to give you a future date though. And so what I've been doing is I've been looking in ducks. What's going on in the case? Is it early? Is it late? Is it post-decree? Is it pre-decree? Did you have a trial date, or, all those things? And then I try to pick a date that's going to be for status in front of that judge. And I've been frankly picking July in the hopes you'll see that judge in person on that date.
Okay.
There's a few people who've commented that they've tried to call, but they've been told that they cannot get a date or time.
Yeah.
Go ahead, Judge
Davenport.
Right. It is an issue right now. And so what we're going to do is to clean this up. The easiest way to do this is have both counsel, let's assume there's 2 counsel, fill out the reservation form. Put down that you want June 29th at 10:50 for status, whatever. Email that in. The clerk is going to, the scheduler is going to look and see, okay, is that date available? Then they're going to have to contact you and say, no, it is not. What other time works? So I think maybe if you want to keep it simple, email in the request and then let the scheduler respond to you, okay? That might make it easier on everybody because as of right now, no, some of them don't think they're supposed to be giving out dates, whether that's wrong or right, Tim, but they don't know. So my suggestion is if you want a date, fill out the information with all the emails, the phone numbers, send it in and say, this is the date I want. Some of the requests that I've gotten have said May, whatever, for status. please advise us to what's available. And then the clerk or the scheduler will call you and say, here's what's available on that date. That might make it easier. It's not involving 2 steps then, where you just send in the request and then let them respond. And if Tim thinks that's a good idea, Judge McJoint will then let staff know that's probably a cleaner way to do it.
I think that's another way to go about it, and I like it. If you recall, one of the earlier administrative orders set up a protocol for pretrials. And the protocol was the lawyer submits a proposed pretrial order with 3 preferred dates, and the judge picked the date. It's kind of similar to that. So yeah, we can go that route as an alternative to just calling first.
Okay.
A question about the Zoom invitations that I see coming up. Judge Hayes, do you guys want us to accept the Zoom invites?
No, you don't need to accept it.
Okay.
Because again, I have gotten feedback, you know, people responding back to my personal email saying, I got it. The only time that I'm gonna do something is if I get an email kicked back, which I have gotten a lot of, you know, and usually it's just 1 letter is off on the form that I have in front of me. And then I just have my staff follow up, get the right email and just correct it. But no, you don't need to accept it. I'm not checking that. I'm only checking, and I usually get it back right away that the email just didn't go through.
Okay, thank you.
Mm-hmm.
We'll try to do 2 more really quick ones because we're almost at the end and the judges do have to get back to their calls. But someone's asking, this seems to be getting kicked up to the top of the list. The preferable way to submit the exhibits for the Zoom hearings, and are those going to be limited to the 25 pages? Do you want us to drop off flash drives? Do you want everything submitted through email, but then you have to print everything out? What's the court's preference for that?
Who do you want?
Sorry, well, anybody? Judge Davenport, Judge McJoint?
Well,
Sure.
go ahead.
As far as I'm concerned, there shouldn't be a page limit if it's electronic. That's the whole purpose. And then we don't have to print them out. We can read them online. We can read them from home. We can read them here. So I would expect that exhibits that you wish to offer into evidence are sent to me electronically and a couple days ahead of time, as Judge Alvarado indicated. But in terms of a page limit, it's not an issue for me. If it's an exhibit coming in, we wouldn't have a page limit if they were standing in front of me for the exhibit. So I don't think it's reasonable to assume that just because you're submitting it for me, my review beforehand, there should be a page limit as well. If we want to print it out, that's on us to print it out, but we don't have to do that. You can read them online.
Okay. Well, this will probably be the last question because we're almost at 1 o'clock. I noticed that there's been a couple of questions about interpreters, and we had asked about this last time. So is there any more information on interpreters, and what if the attorney who's representing the client, this is often the case, actually speaks the same language as the client, which would be other than English? Could they, if they sign an affidavit, be the interpreter for the client?
Okay, interpreters now are, when they're needed, are being invited to the Zoom. We have their emails, the interpreter's emails. At least I do. I'm not sure if the other judges do because I just got it. You still need an interpreter order. It still needs to be approved. It still needs to be submitted to the chief judge's office. All this has to be done now electronically, obviously, and that'll also be done ahead of time, especially when you have or need an interpreter that isn't Spanish or something else. Then it's going to get trickier. But there is a procedure for that.
Okay. All right. Well, we are now at 1 o'clock, so we know that all of you have to get back to your calls. Vicki, Wendy, and I cannot thank you all enough for participating in this and helping our attorneys get through this and providing the information that you're providing. We greatly appreciate it. And also, I want to give another thanks to Barb and to Robert for helping us set up this meeting so that we can get all this information out there. All right.
Good. See you soon.
Thanks, Henry. Thanks, Vicki.
Thank you.